The Big Issue. Breaking down the issues that matter.
Hello, everyone. Welcome to Leadership Podcast. It is yet another edition of The Big Issue. And of course, I am your regular host, George Agba. And without taking much of your time today, we'll go into the big issue of the day. But before we do that, I will appeal that your contribution to this program by way of your comments, send them in, will help greatly in setting the agenda for today's program. And of course, the big issue of the day is conflicting court orders as NJC's hammer dangles on erring judges. And of course, with me here in the studio to actually discuss the issue is our guest, an Abuja-based constitutional lawyer. And of course, he's here to actually give us the legal implication of some of these proofs by the NJC. And of course, his name is Barrister Paul Omoluabi.
Thank you.
You're welcome to the program.
Thank you.
And of course, it's like instead of Paul and Silas, I have two Pauls with me here in the studio. Our regular host, our regular panelist, Paul Agbo, is also here.
George, it's a pleasure to be here.
You're actually welcome to the program. And of course, on Monday, the Chief Justice of Nigeria, Justice Mohammed, Tanko, and three other very senior judicial officers, including the President of the Court of Appeal, the Chief Judge of the Federal High Court, grilled 7 chief judges over conflicting orders in their various jurisdictions. At the meeting, the CJN directed 3 of the judges who granted conflicting ex parte orders to appear before the National Judicial Council to show cause why disciplinary action should not be taken against them for granting conflicting ex parte order. At that meeting, the Chief Justice of Nigeria was said to have lost his cool and descended verbally on the chief judges over recent conflicting orders that have emanated in their states in the last 1 month. And of course, these were the judges that were invited by the Chief Justice of Nigeria last week. I think 6 were invited. And then when the judge in Delta State issued his own ex parte order on the APC leadership, he was also invited. So after the meeting, it was very clear that all heads of court in the country and the leadership of the NBA will be meeting with the NJC to deliberate on the issue. And of course, the CJN warned the CJS to henceforth avoid necessary assumption of jurisdiction in matters with similar subjects and parties already before another court. He said they must protect the court from lawyers who are out for forum shopping and work in tandem with all their judges to salvage the image of the judiciary. Well, Barrister, we'll start with you on this issue. This is the very first time the CJN will come very hard like this. Of course, we have always heard him issuing sometimes warning at events. He will say he warn against ex parte orders and interim injunctions that are frivolous. And of course, the Supreme Court, you had always said it severally, that the court of law is not a Father Christmas that should be issuing and granting reliefs. The ones that were not even sought for in the lower court, they will grant. Some ex parte orders that has nothing to do with their jurisdiction, they will grant. What is your take on this CJN's directive that 3 judges should face disciplinary action?
I must first and foremost place on record that I appreciate the step that the CJN has taken so far. It is indeed proactive, but however, we should also be careful because it has been a settled position of the law that when we have courts of coordinate jurisdiction, like as we have seen in this instance, we have different courts from various states having conflicting court orders. it is the law that decisions from a particular state is not expected to bound decisions from another state. The respective courts in different states have been empowered to exercise jurisdiction within the purview, within their respective states. But however, it has become very embarrassing where similar matters, similar parties, similar subject matters are presented before the same court in different states, and we are seeing different results, as it were, different judgments and all of that. But without preempting the outcome of what may be what the NJC may eventually find out, I must say that the courts are not Father Christmas, as you have rightly said. But however, it is what you pray for that the courts will grant. Legal practitioners have a major role to play in all of these issues. If a legal practitioner who is aware that similar matter, similar parties are before the same court in a different state, ethically it is expected that he has a duty to the court to disclose that there is a matter of similar nature in a sister court, in a court of coordinate or corresponding jurisdiction. And when he fails to do that, then one will begin to get worried that there's something wrong.
Well,
Thank you.
Sorry, some Nigerians are saying that the disciplinary investigation should act speedily so that it will serve as deterrent to other judges who are always flouting the orders of the CJN.
Yes, it is important we call on the disciplinary committee to look at all of the dramas that have happened. But however, it is also important that we should not just call on the disciplinary committee without giving the opportunity to characters that have been involved in all of this drama. We have judges who sit in their own court, who may not know what is happening in another court because they are preoccupied with series of matters before them, and lawyers come before them with series of applications. The judges are aware that ex parte application should be granted sparingly, and the prayers, applications, or requests or affidavit before the ex parte application must be compelling, must be cogent enough for a court to be moved to grant an ex parte application. It's a settled law. It's a settled position of the law. Judges involved are aware. But however, when you bring facts that are very compelling and a judge refused to grant an ex parte order and it affected the rest, I mean the substantive matter,
The rest of
the case, it also casts an aspersion on the judge that he refused to act when he's expected to act. But the Supreme Court has warned severally that judges should be extra careful in granting ex parte application. But I will look at it from this perspective, that legal practitioners have a duty. They have a major duty to the courts to be transparent enough to be able to say, look, we are not before your court for forum shopping. And also, most of these applications, there are undertakings that in the event that it turns out to be frivolous, a legal practitioner should be liable. Because a judge who sits in his own court is so busy that he may not know what is happening in another state. And it turns around that there's a conflicting judgment. Then he is expected to answer for a crime that he ordinarily didn't know how it all generated. So the law hasn't changed. It has always been the law that a decision from Rivers State High Court is not binding on Kebbi State. But however, on a merit, because the public is watching and the judiciary is the last hope of the common man. If the public lose confidence in the judiciary, it will be difficult for them to know where to run to.
Okay, Barrister, you've just said it. And of course, I would have at least expected that you would be the one that would say that, because You are a member of the bar. At the end of the day, you said it very clear. From what you've just said is that in this idea of frivolous and conflicting court orders, even the lawyers, the legal practitioners who are involved, they are culpable. And of course, you see the idea of forum shopping begins from them. Sometimes the judges too might be innocent because they might not know that this particular case is before another court in another jurisdiction.
Very well.
What do you think? Don't you think the bar should
We see
win the big
these are areas that the judiciary should begin to look
NBA,
into.
yes.
The NBA, when I mean the judiciary, all the players involved in the judicial arm of government, there's always room for improvement. It's obvious there's a lacuna somewhere where we should be able to check matters that may likely conflict, because there are no mechanism as it stands now for a court in Kebbi State, a state high court in Kebbi State, to know what is happening in Rivers State. There are no mechanism unless until we improve the judicial system, where we have an electronic system that matters that are filed, which may be quite tedious because matters are filed every now and then. There must be a central data, maybe from the Supreme Court, that monitors all matters that are filed in all the 36 states of the Federation. In all the 36 states of the Federation, to ensure that this is similar subject matter, these are similar parties, there must be room for consolidation. So that if a legal practitioner appear before a state high court in Kebbi or in Rivers State, the court can easily direct that a sister court or my brother in another court is already handling this matter. I will either transfer, because in state high court there's no room, there's no provision that a state high court can transfer his matter to another state high court. So there's a room, there's already a lacuna there. This issue has thrown up that there is a lacuna that legal practitioners and particularly politicians are taking advantage of. Because a legal practitioner equally sits in his office and is brief, and he takes up the brief. He approached the court, the relevant court within that jurisdiction. He may also not know that the same politician has not disclosed that he has breached another lawyer in another state. So there is a lot on the hand of the judiciary that they should begin to look at how to check conflicting decisions that will heat up the polity of the country.
Well, of course, the CJN went for that warn judges to desist from granting expert orders, especially on political matters. Can that be possible? If you know what that means. You can issue expert order in other cases, but when it comes to political matter,
the judges need to be circumspect in this matter. I will not entirely agree with the learned counsel here that some of these judges, you can't blame them. You can excuse them not knowing what is happening in another state. Take, for instance, the case of the Abga matter, flying to Jigawa. A judge who knows his job very well should know that, look, this matter, he knows that it's an Anambra matter. And he should be able to do his research. He shouldn't be pushed to the wall by politicians and lawyers. He should do his own research. And that is why this embarrassment. If some of these judges did their due diligence, they wouldn't have landed in this hot soup. So a judge, like the Martin now said that judiciary is the last hope. That judge is the last hope of everybody that goes into his court. That look, he or she is going to get a judgment. So, and his pronouncement counts a lot. So he has to be very careful. And that is why I said I will not entirely agree. A case from Anambra, Abga, in Jigawa, in Imo.
I think
the case from Rivers landing in Kebbi. The judge should
No,
do
but,
his.
but what you fail to understand is that the learned counsel here did not say that he's not exonerating judges.
Let me say this. Let me say this. I want to correct. I want to correct an expression. When he says that it is expected that a judge should do his due diligence, we're talking about ex parte order here.
Yes.
And the foundation of application for ex parte order is always issues of expediency. It is important that this application should be granted now, and that there are issues that may be destroyed. So, at what point would you expect a judge who is expected to run through paragraph of affidavits that runs into volumes
A matter that
to
is
begin to
emanating
make
from jurisdiction.
consultation for due diligence when a lawyer, a legal practitioner who knows the implication, who knows the ethical issues, who has ethical issues at the background, that ex parte order must be brought, considering the fact that he has also deposed on affidavit, or his client has deposed on affidavit, that there's an urgency. And you expect a judge not to even look at that application or suspend proceeding and embark on due diligence. It will also bounce back on him that there are applications presented before a sitting judge, and he says he wants to embark on due diligence. It's unheard of. It's unheard of. A due diligence will only come up where any of the parties in the suit raise it up before the judge and say, look, my lord, there is this other, my adversary is here for forum shopping, and he canvass his own facts that there is a similar matter before your learned brother in another state, and that they've even gone far more than this, because sometimes some of these matters, some would have even gone far at the hearing stage, and some will just be starting on same subject matter, on same issue. So it is the duty of the legal practitioners who comes before a court to sufficiently disclose what has transpired outside. Remember that a judge is not even expected to be seen as such, quote unquote. He's not expected to relate to the public. He sits there, his business is to look at. He's not expected to delve into the conflicts. Is expected to be impartial at all time. So what due diligence will you expect a judge to suspend application, a serious business in court, and begin to ask questions? Who is he going to ask the questions? So I think, though the judge they have their role to play, but on these conflicting orders, I think their role is very limited. Judges' roles are limited. The challenge is on NBA. We have lawyers that are members of NBA, and NBA is supposed to wake up to their responsibility and begin to call these legal practitioners to order that, look, you are creating problem for us.
And you are misleading the bench.
You are misleading the bench.
Well, before we continue, let's quickly take a short break for some kind of public announcement. We will be back in a moment, but before we go, I'll still say to our viewer, don't forget to contribute to this program by way of your comments. Send them in, read them to the public, and then they will understand your view. We'll be back in a moment.
The Big Issue. Breaking down the issues that matter.
All right, welcome back. Of course, we are still on the big issue in Leadership Podcast. And of course, the big issue of the day is conflicting orders as NJC's hammer dangles on erring judges. As we were talking, Paul, you had something to say. It's like you were trying to
Well,
the learned counsel.
yes, he did well to defend his folks, both on the bar and the bench. But I must say that, look, the actions of the judges are not helping democracy in Nigeria. We must say the fact. If you look at the timeline of some of these conflicting orders, you recall just yesterday, the INEC chairman, Professor Mahmoud, lamented the same issue, that sometimes elections are won without a candidate in this same country because of some of these conflicting orders, making the work of INEC difficult. In 2011, I just want to give you a brief timeline of some of these conflicting court ex parte orders emanating from courts. In 2011, courts of coordinate jurisdiction bombarded INEC with conflicting ex parte order, forcing the CGM to intervene. The same thing repeated in 2016. 6 conflicting judgments in the leadership crisis, one of the major political parties in the country. And in just before the general election, this same INEC chairman lamented the spate of conflicting judgment by the courts, especially of coordinate jurisdiction on electoral matters. That's embarrassment. It's a mockery. It's making jest of our democracy, where lawyers run to court to forum shop,
Looking for
some people call them black market judgment.
Give them a favorable judgment.
Yes, black market judgment. It's embarrassing. It's slowing down our democracy. It's not giving our democracy credibility.
But wait,
Zap.
Paul, before you go, let me ask you a question. Wait, let me tell you something. The INEC talking, they too have their own problem. I could remember on several occasions, like in one of these judgments on electoral matters, I could remember where the justices of the Supreme Court came hard on INEC. Who was that? I think one of the retired chief Supreme Court justices, Justice George Oguntade. He said INEC turned the electoral process into animal farm, where some animals are more equal than the other. You don't understand. So if INEC talks, you should understand that they too are not actually exonerated from some of these this kind of legal issues, legal somersaults that will always affect the electoral system in the country.
I'm trying to make is this.
Except under Yakubu, he has come to sanitize the electoral system.
The leadership of the bar need to work on it, on itself. You need to work on members of the Nigerian Bar Association. Those who will run from Port Harcourt to KB, and those who will run from Oka to Owerri, and who will run to Jigawa, they need to work on their members. Well, they should stop embarrassing us. Yes.
But let's hear what
I agree with you to some point that some of these conflicting judgments could be very embarrassing. But however, the only way out, the CJN has come up and is calling that those who are involved should be asked to face sanction. I think there should be preventing measure in place, not this reactive approach when we already have conflicting orders before we start reacting. We are lawyers, and the judiciary can begin to. The judiciary the CJN has power to come up with regulations if there are sufficient regulations. Because I read one point here that how do you expect, assuming, because you said it here that a lawyer can jump from Rivers State to Kebbi State. A lawyer is a lawyer in Nigeria and is expected to practice in the entire every jurisdiction in Nigeria. But however, a judge who has been appointed by state sits there in his own court. He doesn't know what happens in another court. All of this can be put to check. That there should be a way where matters like this, matters that are very sensitive, there should be a national data for it, where special bodies from the CJN, from the NJC, monitors who fight, monitors that legal practitioners undertake, that there is no any other person out there.
Well, sorry, Barrister, before we continue, I think our viewers started sending in their comments. Let's just take them so that at the end of the day, we will form basis of our discussion here.
Thank you.
And of course, we have Adebayo Amodu. Adebayo Amodu is saying sanity must be restored in the Nigerian judiciary. I commend the CJN for taking the right steps by summoning the chief judges of the state involved in the current abuse of our court process. He should ensure that the erring judges are punished. The NJC should wade into the matter and discipline erring judges as it has done in the past.
Yes, he has.
Of course, he has something to say again. He said, to save our democracy, the chief judges of state must also rise up against this ugly trend.
I quite agree with him.
I will only agree with him when the outcome of the NJC says that they are at fault, because these judges have to be given a fair hearing. If a judge comes up and tells you that he was never aware that there is any other matter whatsoever, and you that he was not aware that there is any matter in another state, what do you punish him for?
Well, but don't forget, 7 chief judges of the state were invited, and at the end of the day, only 3 judges who issued that. That means 7 judges in 7 states issued the conflicting order. But let
us even break it down.
3. Don't you think that the
let us break it down. The judges that were invited were not the judges that even sat over this ex parte order. They were the heads of the courts. But however, as the head, you assign these matters to these judges. It will still boil down. They only came to be cautioned, where they will go back and caution their own judges that are under them. It will be, I will say it over and over again, that if a judge comes before the NJC and is able to assert that he's not aware, is able to show that he's not aware that it is what they presented before him that he worked on. And remember that most of these rulings are backed up by law. They don't just grant ex parte order. There are reasons why these ex parte orders are granted. Lawyers, ex parte order, though, an ex parte order, we know that it's just for a period of time. And the lawyer who moved the ex parte motion has canvassed certain reason why an ex parte order should be granted, why the other party should not be put on notice. So the judge did not just wake up and grant ex parte order. And ex parte order, we all know that is an exception to the principles of fair hearing, because the other party is not put on notice. And the reason why the other party is not put on notice is because there's an urgent need that if we have to take the pain or start putting the other party on notice, that need will not be met. Which is why an ex parte is granted pending the hearing. Note that ex parte is just for a period of time, and that immediately the ex parte is granted, the other party is also put on notice. So if a judge says he's convinced, you have appointed a judge. You cannot have 2 judges in the same court. You have given him the discretionary power, but the law says that discretion should be used sparingly. And if he says he's using this discretion sparingly and he's convinced, and he goes ahead and grants this ex parte order, because the man who is moving the ex parte order with the legal practitioner did not disclose that there's another ex parte order that already been granted, how do you punish that judge?
And now the CJN said that henceforth there should be no ex parte orders on political cases. Is that possible?
That's just merely a political statement with due respect to the CJN. Until there is a legislation, in as far as it's a civil suit, Of course, if lawyers, legal practitioners are able to canvass their cases, an ex parte order should be granted.
More will come.
More, of course, more will come.
But my only
But
worry is
the CJN,
the
with
judges-
due respect to him, is worried about how the judiciary is being dragged. And he has made this statement, but we must see him take further step with the NBA to see how they can begin to put check to some of these ex parte orders. If the NBA and the NJC refuse to do something about this, I can assure you we are going to continue to see more of it.
Yeah, most Nigerians are saying that the judiciary, especially the highest body, it's like the mechanism put in place to deal with erring judges, and the rest is not too strong, because in some cases, even some judges have had this kind of issue, and whenever they're invited, they go away with it scot-free. What are you expecting from
I will
particular-
not say that the mechanism put in place is not firm enough. The mechanism put in place has always been very firm. Remember, you are dealing with lawyers. The judges are lawyers. The legal practitioners are lawyers. They all come from same training. So the training they have, you are expected to give them fair hearing, and you expect them to defend themselves. If they successfully defend themselves, or they defended themselves successfully well, then of course the public will begin to see that the mechanism put in place is not firm enough. They are not punished. And most time the public is not there when they put up their own defense, letting the chairman of the NJC see reason why they have to go this way and all of that, and they are set free and go back to work. The mechanism put in place is fair. Lawyers have been punished several times, judges have been punished several times, and if the facts before the NJC is overwhelming and they cannot defend it, and I can assure you the NJC will punish them. So the mechanism in place is fair. The system, upon the arrival of these conflicting judgments, is what I'm worried about. What I'm worried about. We have hierarchy courts, and the state high courts have corresponding jurisdiction. You can't change that. It's a constitutional issue. You can't change it unless we have to go and start amending the constitution to say that if a decision comes from Niger State, it's binding on Lagos State, which will be awkward, which will be absorbed, because there are peculiarities in these respective states.
Well, I think that is it. That is all we can take for this program. Thank you, Barrister, for coming to this show. It was nice having you. And of course, Paul, it was a very good one. Well, that is the much we can take for today's edition of The Big Issue. Join us same time tomorrow for another edition of The Big Issue. Have a nice day.
The Big Issue. Breaking down the issues that matter.